If you've been named as a trustee of a trust in California, there's a good chance you're feeling overwhelmed or at least unsure about where to start. Most trustees didn't ask for this role. They may have stepped in because a parent, a spouse, or a loved one trusted them. And suddenly they're responsible for legal duties, financial decisions, and family expectations. I'm Jonathan Huber, a California State Bar certified specialist in estate planning, trust, and probate law. In this video, we'll walk through what it really means to be a trustee, your responsibilities, common mistakes to avoid, how long the process typically takes, and how our firm supports trustees through the process. As a trustee, you are what the law calls a fiduciary. That sounds intimidating, but in plain English it means three things. First, you must act in the best interest of the beneficiaries, not yourself. Second, you must follow the instructions of the trust document. Even if you think a different approach would be fair, the trust controls. And third, you must manage trust assets responsibly. That includes safeguarding assets, making reasonable decisions, and asking for professional help when needed. You don't have to be perfect, but you do have to be careful and intentional. One of the biggest misconceptions trustees have is timing. Trust administration does not happen in a few weeks. In most California cases, it takes several months to over a year. Early on, you'll be identifying assets, sending required legal notices, and securing accounts and property. In the middle stage, assets are valued, expenses and debts are paid, taxes are addressed, and beneficiaries start asking questions. Toward the end, distributions are made and the trust is formally wrapped up. Trying to rush this process is one of the easiest ways trustees accidentally create legal problems for themselves. Most trustee issues aren't caused by bad intentions, they're caused by lack of guidance. Some of the most common mistakes we see include making distributions too early, failing to communicate with beneficiaries, mixing trust funds with personal funds, or ignoring accounting requirements. Another big mistake is trying to do everything alone. California allows and expects trustees to rely on attorneys, accountants, and financial advisors. Getting help isn't a weakness, it's often what protects you. A common question we get is, what does the trustee handle and what does the law firm handle? At Huber Law Group, we guide you through the legal side of trust administration. That includes interpreting the trust, preparing required notices, advising on distributions, coordinating with professionals, and stepping in if disputes arise. As a trustee, you stay in control. You locate assets, approve payments and distributions, sign documents, and make decisions with our guidance along the way. Our role is to protect you, reduce risk, and make sure the process stays on track. Being a trustee is a serious responsibility, but you don't have to navigate it alone. With the right guidance, trust administration can be handled efficiently, correctly, and with far less stress than most people expect. So if you've been named as a trustee and have questions about your role, timing, or the next steps, contact Huber Law Group to request a no-cost initial consultation. Thank you for watching.